Good evening, ladies and gentlemen. I am happy that you have returned for our fifth session of Constitutional Revival with Royal Alexander. We have an exciting night tonight with the First Amendment. I want to begin by thanking everyone again for your contributions, and just want you to know that that is what makes it possible for us to continue to remain online. We will continue to accept donations through Venmo and also through my P.O. Box, which is P.O. Box 1837, Shreveport, Louisiana, 71166. Again, P.O. Box 1837, Shreveport, Louisiana, 71166. And the check can be made out to me, but in the notation line, please put Constitutional Revival. I want to again thank Joanne Woodard and David Hagar, who without whom this would not be possible. And keep in mind, David's company is named Beyond Innovative Technologies and Consulting, and he does a great job for us. I also want to say anyone wishing to review the material can go to my YouTube channel, Constitutional Revival with Royal Alexander, and we will keep plugging along and making progress. As I said, we left off last week. We finished the articles, the 7 articles, and tonight we go into the First Amendment. If you have any questions, we will take them at 7. We will go to 7, and then we will go as long after 7 as there are questions. If you have any email issues or you want to send me a question, please do so at constitution.royalalexander@gmail.com. Again, constitution.royalalexander@gmail.com. And tonight we begin the mighty First Amendment. And the First Amendment is so important. It is so very important in our constitutional structure. There are 5 parts to it, really, but the one we're going to focus on tonight is freedom of speech. But the First Amendment includes freedom of speech, press, freedom of press, freedom of petition, assembly, and religion. And free exercise of religion includes the Establishment Clause, which we'll get to in due time. But those are the 5 basic freedoms of the First Amendment. Again, freedom of speech, press, petition, assembly, and religion. And along with religion, we have free exercise and the Establishment Clause. While all 5, obviously everything in the Constitution is important, while all 5 rights in the First Amendment are very important, the one that is focused on and talked about the most of all of them, and there's several that are talked about quite often in our society, in national news, online, on TV, on radio. Freedom of speech is probably the one talked about most in the whole Constitution. Freedom of speech is the cornerstone of our democracy, the cornerstone of our democracy. And in particular, what I'm talking about is core political speech. Now, I'm going to explain more about different kinds of speech in a few minutes. But when I say that freedom of speech is the cornerstone of our democracy, again, I'm talking about what I'm going to define in a few minutes as core political speech. Although we know this, but although what we say publicly can have consequences, like we can lose friends or maybe even lose our jobs, it still gives Americans the right to express opinions without government censorship or control. Government censorship or control. Again, if we have a private employer, we potentially could be fired for something we say. We may lose friends. We may get in arguments with our family. But the government cannot censor or control our speech. And I'm, again, talking about core political speech. Most importantly, though, of all of it, you can't go to jail for expressing your opinion, no matter how offensive or obnoxious, if it qualifies as core political speech. And it's a broad category. It not only protects speech that we like, but most importantly, it protects speech that we don't like. Because when it comes to free speech, Either everyone is protected or no one is protected at all. It's either a principle that guides and directs our conduct and behavior, covering all of us, or it covers none of us. And we're going to talk about how targeting speech, particular kinds of speech, is usually unconstitutional in a few minutes. But free speech either protects all speech or it protects none. It allows citizens in this country, in this free nation, to support political movements and candidates and many other things. It gives people the power to call out government corruption and abuse. And that's a powerful right. The power to call out corruption and abuse of our government. Many other places in this world, many other nations do not allow that. Do not allow the government to be criticized. Most importantly, though, it empowers people to give unpopular opinions. Please keep in mind, and I'll say it more than once, the speech we all like is not hard to be tolerant of. It's the speech we find obnoxious and offensive and blasphemous and insulting. That is the speech that is most in need of protection. If the speech is something that a majority of the people accept, it's no real challenge to be open to that speech, to be tolerant of it. It's speech that offends us that we also have to be tolerant of if we're really going to say that we enjoy freedom of speech in this country. In a politically charged climate, you know it as well as I do, some people believe government should restrict certain speech. We're going to address that later. And you know what I'm talking about. We all have examples that we've seen of people say that kind of speech ought to be restricted. The problem is, once you start going down that path, who gets to determine which speech is restricted and which speech isn't? And I promise you, that's the path of totalitarianism and authoritarianism and a dictatorship. And that's a scary path to start to go down. So even though there are people in this country who believe that government should restrict certain kind of speech, like hate speech, it sounds so nice until you try to define what hate speech is, because all that bumps up against First Amendment and our freedom of speech. However, thankfully, the U.S. Supreme Court, with which I disagree often, our U.S. Supreme Court in the last 60, certainly in the last 50 to 60 years, has given great protection for everything from commercial speech, which I will address, to fiery protests. It's all protected with certain small stipulations we will address. Now, I want to say again, the First Amendment restricts Congress. It talks about what Congress can and cannot do. Well, the U.S. Supreme Court has held many times that speakers are also protected against all government agencies and officials, federal, state, and local, legislative, executive, and judicial. So the U.S. Supreme Court has interpreted Congress to be far more than just the federal government. It has expanded it to virtually all kind of government. Any form of government cannot restrict core political speech. So it's much broader than just the words of the First Amendment themselves. The First Amendment does not protect speakers, however, against private individuals or private corporations. And that's where defamation comes in, things like that. When we're talking about who can restrict our speech, we're talking about the government, which is a broad and usually powerful force in our country at all levels. But again, that doesn't include our ability to defame someone like a private individual or a private corporation. The First Amendment only restrains government. So we'll keep that in mind. I want to give you some background. The U.S. Supreme Court has described the need for freedom of core political speech as being and advancing the need for uninhibited, robust, sometimes raucous, wide open debate, heated, sometimes angry. All of those ideas get tested in the marketplace of ideas. The marketplace of ideas. Speech gets tested in the marketplace of ideas, and the best idea will prevail and gain support, gain votes, gain support in the country or in the community. But again, what is core political speech designed to be under the First Amendment? Uninhibited, robust, sometimes even raucous, wide open, heated, sometimes angry, because that's how people express themselves in the marketplace of ideas, where the best ideas, the best speech gets tested. And it either gets accepted or it gets rejected, but it gets to be heard. It gets to be heard. That's the most important principle underlying the First Amendment, freedom of speech. And I want to say how broadly it is too. Core political speech consists of conduct and words, as you can imagine, that are intended to directly rally public support for a particular issue, a position, a candidate. In one prominent case, the U.S. Supreme Court said that core political speech involves any interactive communication concerning political change. Let's think about how broad that is. Any interactive communication concerning political change. That's pretty broad. Any interactive communication. That's very broad concerning political change. Political change can be virtually anything. That's how broad and open the First Amendment area of core political speech is supposed to be. But keep in mind, we have to pay attention when we're not talking about the government. You know why it's so free and uninhibited and wide open, and why we're allowed to criticize the government? Because if we weren't, we would be chilling, to chill, tamp down core political free speech. That chilling effect is something the Supreme Court guards against all the time. You'll see the words chilling. It will have a chilling effect on speech. That's why so much speech is allowed when it falls into the category of core political speech. So we'll keep that in mind as well. A discussion of public issues and debate on the qualification of candidates. For example, right now we have a very heated presidential election going on. There's some other heated races, but in the national consciousness right now is this presidential election. And in those areas, the Supreme Court concluded those forms of expression are integral to the system of government established by our federal Constitution. That's why I say freedom of speech is the cornerstone of our democracy. The Supreme Court has said similar things many times. You can't have a constitution which makes us a republic, and in our republic, we govern ourselves in the form of a representative democracy, the U.S. Congress. Tripartite government, remember, judicial, executive, and legislative. Our government, the Supreme Court says, cannot function if we don't have this protection, strong protection of core political speech. So what are some of the examples? You'll recognize some of the traditional ones long before the internet, long before TV, and even radio. So circulating handbooks, circulating petitions. Right now there's a petition to Recall Governor John Bell Edwards. Shreveport frequently has petitions of one kind or another. Petitions, handbooks, handouts, brochures, posting political signs and placards, and making speeches and orations are all forms of core political speech, so long as they, and we know it's broad from a few minutes ago, so long as they in some way address social issues, political positions, political parties, political candidates, government officials, or government activities. Do you see how broad that is? Again, any interactive speech a minute ago that addresses change. Interactive. Do you know what interactive means? Any interaction between human beings that addresses political change. And as I said, political change is virtually everything. So again, all of those areas qualify as core political speech. Handbooks, petitions, going door to door. Again, you're on private property then, but on the sidewalk you are not. Candidates go around door to door all the time. Those are traditional ways, posting signs, placards, yard signs, many, many other things. Anything that addresses a social governmental issue or a candidate. For all of these reasons, I say again that the First Amendment elevates core political speech above all other forms of individual expression. The First Amendment, I'm going to say it again, elevates core political speech above all other forms of individual expression. By prohibiting laws that regulate that core political speech, unless the laws are narrowly tailored to serve a compelling state interest. You know what that is? That's strict scrutiny. It's what the court refers to as strict scrutiny. It's the highest level of scrutiny, and virtually by the Supreme Court picking strict scrutiny to use to analyze a particular regulation or statute, you're almost guaranteeing that the statute is going to be struck down. Why? Because strict scrutiny requires that the interest be narrowly tailored to advance a compelling state interest. Narrowly tailored to advance a compelling, not a kind of important one, a compelling state interest. It must be narrowly tailored. So if you're going to restrict core political speech, it's got to be tiny, 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 if it has any chance of passing strict scrutiny. Again, strict scrutiny is the most intense, most demanding form of analysis the court uses to decide whether a restriction of speech is valid or invalid. And as I say, most of the time, it's invalid. Okay, keep in mind strict scrutiny. This is especially true when we're talking about strict scrutiny, when the core political speech is expressed in a traditional public forum. What is a traditional public forum? Streets, sidewalks, parks, and other venues. Streets, sidewalks, and parks are, from time immemorial, traditional forums for speech. They are avenues that have been traditionally voted to public assembly and social debate. These traditional forums. Sidewalks, parks, and other venues that have been traditionally voted to this form of social debate and social assembly. Strict scrutiny is also applied to laws that regulate core political speech in designated public forums. So we have traditional public forums, which we talked about, sidewalks, parks, and other venues, streets, sidewalks, and parks. Those are traditional public forums. But we also have designated public forums. Again, these are distinctions the court has drawn. Strict scrutiny is also applied to laws that regulate core political speech in these designated public forums, which are areas created by the government specifically for the purpose of fostering political discussion. For example, state fairgrounds. State fairgrounds were traditionally a designated public forum in which people could engage in core political speech. State fairgrounds and other similar venues can be considered designated public forums under appropriate circumstances. Now, traditional public forums and designated public forums are the most common areas where it is virtually impossible to restrict core political speech. There are non-public forums, however, that receive lower level scrutiny if someone is trying to engage in core political speech in a non-public forum. And those kind of areas are households, mailboxes. The mailbox is right out in front of someone's home. Military bases, airport terminals, indoor shopping malls, and most private, commercial, and residential property. If something's privately owned, obviously, someone could very well be trespassing to be on the property at all. But places like malls, which are open to the public, military bases, airport terminals, indoor shopping places, those are all places that core political speech could be engaged in, like passing out brochures in front of the Walmart. That's a place people publicly go in and out of all the time. Of course, Walmart could say, this is private property, and even though the public comes here, we would prefer, we're going to keep you off our property. Y'all can go out there to the sidewalk, but we don't want you to be right on our Walmart property. They could do that. So a regulation allowing Walmart to do that would receive less scrutiny because it's private property, and because that private property may be a public forum, but it's a non-traditional, non-public forum. So again, when we're talking about the First Amendment and core political speech, the speech in those traditional public forums and designated public forums are virtually sacrosanct. You virtually cannot restrict speech there because strict scrutiny will be applied. The most narrowly tailored way of achieving the compelling interest. And you can always make something more narrowly tailored, which is why the court most often strikes these down. So again, it has been deemed just as part of the fabric of our country, the fabric of our nation, that in these broad areas of free speech pertaining to core political issues, core political speech, that speech is virtually not able to be restricted. The idea is that the First Amendment allows citizens to express and to be exposed to a wide range of opinions and views. That's what freedom of the press means too. And by the way, let me say that while I'm thinking about it. The First Amendment protection of core political speech doesn't just pertain to the speaker. It pertains to the listener. You have a First Amendment right to hear what I am saying in the area of core political speech. So it's not just my First Amendment right to speak on these issues that qualify as core political speech. You as the listener also have a First Amendment right to hear, to receive my core political speech. And that's hugely important. What are some of the examples? Well, as you can imagine, freedom of speech encompasses not only the spoken and written word, that's how we think of it most often, when we speak or when we write, but also it's broad. It includes all kinds of expression, including nonverbal communication. That's still considered speech, nonverbal communication, such as sit-ins, a sit-in. That's more of an expressive activity than it is a vocal activity, a speech-driven, traditionally speech-driven activity. But a sit-in, art, for example, a sit-in in a government official's office. Art contains expressive qualities which get it protected under the First Amendment. photographs, films, and advertisement all enjoy either complete, virtually, or at least some protection under freedom of speech and the First Amendment. And again, the media, under its provisions, the media, for example, television, radio, and the internet, is free to distribute. That's what we have today, television, radio, and the internet, again, which is both visual, verbal speech, and written speech. They're free to distribute a wide range of ideas and thoughts, pictures and facts and news and opinions, a wide range. And that's freedom of the press. But we are entitled, again, to hear it. We have a right to be sure we hear it. So we have to remember that it's a powerful right both ways. Again, we're talking about core political speech. And I keep mentioning core political speech because I'm going to distinguish it in a few minutes. Core political speech. How can core political speech be restricted? Only if there is a clear and present danger of imminent lawless action. Only if there's a clear and present danger of imminent lawless action. For example, if someone were in Shreveport, Louisiana, if we were at Betty, Virginia Park, and I or some other speaker, maybe somebody we can't stand, maybe somebody from the Klan, maybe somebody from Black Lives Matter, or any other group we might find offensive. The skinheads were giving a speech. They had a speaker in Betty, Virginia Park. They could stand there and say all those racist things that they want to because it's protected speech. It is core political speech. It's protected because presumably, even if a lot of it is racist and bigoted and ugly and despicable, they still get to say it. Because again, if we're going to honor anyone's right to core political speech, then we have to honor all of it. So the only time that kind of speech can be stopped is when, in that moment, when there is a clear and present danger of imminent lawless action. We're not talking about a statute. As we mentioned, a statute regulating the speech of skinheads or the speech of racists or the Klan or BLM. BLM strikes me as crazy and racist as anybody else. I mean, they're Marxists, so I think it's fair to put them in the group. Any of that speech would be regulating it by ordinance or statute would be struck down under strict scrutiny, as I mentioned a minute ago. But I'm talking about being right down there in Betty, Virginia Park. I'm talking about a highly offensive speaker who is speaking, saying the worst things, blasphemous things, blaspheming Christ or God Almighty. All of that is protected speech because the key is we can always leave if we're offended. We can walk away. But the speaker gets to speak. Okay. As broad as the right is to core political speech, and although it will be struck down, the regulation or ordinance, by strict scrutiny, or if it's happening imminently in the Betty, Virginia Park or any park, the only time it can be stopped is if there are clear and present danger of imminent lawless action, meaning violence is literally about to break out. People are literally about to start hitting each other, stabbing, shooting each other. At that point, law enforcement can break it up and stop that speech. Now, if law enforcement was smart, they would have separated people at the beginning. But again, people have a right to speak and have people heard. So it's hard to do. It's a fine line there between a breach of the peace, imminent violence, and allowing even an offensive speaker to be heard. But as in every other case, the right to free speech is not absolute. The U.S. Supreme Court has ruled many times that the government may sometimes be allowed to limit speech. For example, and we're going to address this more thoroughly later, the government can limit libel. It can limit defamation, speech that defames. Defamation receives lower protection. And I'm going to talk about lower protection in a minute. Because defamation is the communication of false statements that can injure a person's reputation and cause them harm. Obscenity is another one. Fighting words and or these words that present a clear and present danger of imminent lawless action. It can be offensive speech, or it can be fighting words, or you go up and insult someone right in the face. The words are only meant to offend. This court has said they have no expressive value. They have no political speech value at all. They're merely to offend. That speech can be prohibited. It's called fighting words. This kind of speech and any kind of speech, even core political speech, to engage in it, you often have to have a permit. That is one of the reasonable time, place, and manner restrictions that the Supreme Court allows under free speech. Reasonable time, place, and manner restrictions, meaning the city of Shreveport can require a permit before the skinheads or, Planned Parenthood or pro-lifers. Anyone wants to go and have a speech in Betty, Virginia Park. The city can require a permit saying, on this day during these certain hours, because if you go all night, you're going to disturb people's peace and enjoyment all around who live in the neighborhood. And people have a right to their peace and enjoyment of their homes. So reasonable time, place, and manner restrictions are constitutional. And again, a perfect example is a permit someone would need to get in order to hold a rally at Betty, Virginia Park. A permit is one of the most classic examples. Now, I want to say again, we are all sensitive. Many of us, or I'll say, are very sensitive people. We can be easily offended. We hold things near and dear to our hearts. Many of us have a strong faith in God, faith in family, faith in country. And it's not hard to offend us. But I want you to know, in the same way your rights are protected powerfully in the area of core political speech, we are also forced to endure in this country utterly distasteful rhetoric, utterly disdainful, contemptible speech. You remember Westboro Baptist, that church, there's only about 6 people in the church. They would go around and protest at the various funerals of American soldiers who came back, who had been killed overseas, maybe in the Middle East, and come back home for a funeral and a burial. You can imagine how many people the Westboro Baptist protesters offended. They said, again, it's good this soldier is dead because his death is a punishment by God for homosexuality. Now, all that's pretty disconnected to me, very attenuated. The soldier died, we would say, defending our country, but these Westboro Baptist people think the soldier died as he was punished by, he didn't die for his country over there. His death was a punishment by God for homosexuality. Those people go to the funerals of soldiers. And again, it's usually 6 or 8. They're vastly outnumbered. But they get to stand there and hold those ugly, inflammatory, just contemptible messages. And they get to use bullhorns. They get to try to interrupt the sanctity of the funeral service and the funeral procession. Now, law enforcement allows them, kind of puts them off in the corner, I've seen, because I've seen them appear at some military funerals I've been to. But that's an example. Those people are mocking the death of an American soldier, saying that his death was God's punishment for homosexuality in America. But again, as offensive as that speech is, it does address national issues. It addresses the military. It addresses homosexuality. It touches on several areas of speech. It's highly offensive. The Westboro Baptist people are highly offensive. It's highly inflammatory, but it is protected speech. But keep in mind that just as that speech is protected, our speech is protected also. And the only way our speech gets protected is if we also protect the Klan and the skinheads and Westboro Baptists and Planned Parenthood and a lot of other things that many of us find very objectionable. It's got to cut both ways, or we don't really have the right. If it's a fundamental right, it's got to be protected for everyone. That is one of the lessons I really want you to take away. Keep in mind, freedom of speech also applies to symbolic expression. This is important. Freedom of speech also applies to symbolic expression. Again, we're talking about core political speech. So what is symbolic expression? Displaying flags, burning flags. That offends many of us. The burning of the American flag offends many of us, but it is protected political speech. It makes people crazy to see the American flag being burned, but the court has deemed it protected political speech for the very reason that the flag is such a powerful symbol that burning it, in the view of the Supreme Court, it makes me mad. In the view of the Supreme Court, burning the flag is really a paramount, a monumental expression of free expression, because the flag represents so much, something sacred to so many of us. So that's an area. Displaying flags, burning flags, wearing armbands. You know, some very offensive armbands. Burning crosses, burning crosses. Now, again, that's associated with the Klan, although really long before the United States had burning crosses, other parts of the world used it for reasons completely unrelated to race. It was a form of expression, but still, in the United States, the burning of crosses was a reflection of the Ku Klux Klan. It's considered hate speech, but again, even the speech that we consider most offensive, most inflammatory, most reprehensible, most despicable, most contemptible, still is protected. We can object to it. And keep in mind, the Supreme Court has said many times, the best response to this kind of core political speech that so deeply offends us is more speech. More speech. If we're offended by what the Klan's doing, we need to go have a unity march and bring all kind of people together for our march. That's more speech. Have speakers who talk about the need to unify the country. That's the response to the Klan, to the skinheads, to Westboro Baptist, to say we support our troops and have a powerful, strong support our troops rally. The best response to inflammatory, hateful, ugly speech is not to suppress that speech, the Supreme Court has said, and we have to believe. It's to respond with more speech that completely contradicts that speech. That's what we do under the First Amendment, freedom of speech, when we're talking about core political speech. The Supreme Court has held that restrictions, and again, this is technical, but what we're doing tonight is straight up Supreme Court stuff. So you can feel tonight, again, as though you were in a law school class, a constitutional law class in law school. The Supreme Court has held that restrictions on speech, because of its content, that is, when the government, and again, we're only talking about government. The term is huge, as I said, but only talking about government. We're not talking about a private corporation, which is why a private corporation can fire people for speech it finds offensive, which is why, a brief aside, the NFL could, not the NFL itself, although it's a private corporation, the Dallas Cowboys are owned by Jerry Jones, just like the New Orleans Saints are owned by Miss Benson, Mr. Benson's widow. Those are private owners. The New Orleans Saints and the Dallas Cowboys are not a government entity, which is what makes people so mad when those players kneel during the national anthem in what many of us feel like is disrespect to the flag. The reason that it makes people angry is because the Dallas Cowboys are privately owned. The New Orleans Saints are privately owned. If Jerry Jones, and I think he's done this actually, told the 44 or 48 members of the Dallas Cowboys, if any of you take a knee, I'm kicking you off the team. He may have to pay their contract out or whatever if they signed a contract to play for the Cowboys or the Saints. If Miss Benson said, you know what, unfortunately, she's going in the exact opposite direction, I think, but if Miss Benson said, if any of the 48 New Orleans Saints players kneel during the national anthem, they're off the team. She might be highly criticized for doing it, but legally she could do it because the New Orleans Saints are not a government entity. The Dallas Cowboys are not a government entity. So please know when I talk about these restrictions on our speech, core political speech here, I'm talking about government entities, and government is a broad word. But again, when the restriction targets the content, the very meaning of the core political speech, it almost always violates the First Amendment. And again, I'm taking a different way of saying to you what I said earlier. Criticizing or any regulation that suppresses, diminishes people's ability to, for example, criticize a war, opposing abortion, advocating for higher taxes, supporting Obamacare. These are all examples of unconstitutional content-based restrictions. What do I mean by that? A content-based restriction is a restriction the government has put in place only and solely because of the content of the speech. I don't want to hear any pro-life speech, so we're going to pass a law that pro-life picketers cannot be outside of an abortion clinic. We're going to pass a law only that targets abortion clinics across the United States. That would be a flagrant example of targeting speech because of its content. You support the pro-choice or pro-abortion movement, and you hate having pro-lifers picketing right outside on your sidewalk, so you're going to pass a law that no picketers can, and they've tried it actually. Picketers can still be out there. They can't go up on private property. They can't be on the private property of the clinic, but they can sure be all day long on the sidewalks, on the streets. Of course, they can't get in the way of traffic. You can't inhibit traffic. But what I mean is they can be there all day long, and they often are on public property. But to pass a regulation specifically that targets those pro-life protesters, pro-life picketers, is based on the content, their belief in the wrongfulness, the immorality, the sin of abortion. And that's the only reason you're targeting them, because you're not doing that to other forms of speech. You're not stopping the neo-Nazis. They can picket and march all day long. You're not stopping the Klan, even though we all find it detestable. But you're targeting pro-lifers. That's a content-based. You're only trying to restrict this speech because of its content. And that applies again to, I use the abortion issue, but criticizing a war. You know, a lot of times governments, particularly during the Vietnam War, would like to have suppressed anti-war speech because it was very heated in the 60s and early 70s, getting us out of Vietnam. But the government says, no, you can't do it. So those are examples of content-based restrictions of core political speech. And they are the most, that kind of speech enjoys the greatest constitutional protection under the First Amendment. Such laws, why? Why no content-based? Why is the protection here so powerful? Because such laws, those kind of regulations that restrict those pro-lifers, that restrict the skinheads, that restrict content, those kind of laws are thought to be especially problematic because they distort public debate. People have a right to hear speech. They can reject it or they can support it, but they have a sacred right to hear it, to hear it. And that's one of the things that distinguishes the United States. short of somebody shooting at each other and stabbing at each other in the park, at a rally, the speech gets to be heard. People could be screaming the N-word. People could be saying all kind of offensive things. But if it has some basis in a national issue, something that qualifies it as core political speech, it gets to be said. And the police just have to hold everybody back. And you've seen people you can have a black protest, say BLM versus the Klan. The police are always smart they should be smart to keep them separated, because both sides get to be heard. And it offends us sometimes. But in being offended, our personal right to speak is protected. So those laws are especially problematic because they distort public debate. And it is public debate that decides what kind of laws we're going to live under and what kind of government we're going to accept. You cannot have genuine, true, authentic self-governance, self-determination, this experiment in self-government, this experiment in democracy, representative democracy we have in this country for only 244 years. This experiment in democracy and self-government cannot work if we allow the government to target speech because of its content, no matter how inflammatory, no matter how offensive, or how despicable or blasphemous we may find it. The speaker gets to speak, almost without exception. So that, I just realized, wow, 47 minutes went by quickly. I wanted you to understand about how powerful this protection under the First Amendment of core political speech is. If there's a statute or ordinance, it's getting strict scrutiny, which virtually always means it's going to get knocked down. If it's something that's happening live, like in a park, like the Betty Virginia Park here in Shreveport, or any other park, or any other traditional forum, public forum, or any other designated public forum, when the crowd is together, the speaker gets to speak right up until there's a clear and present danger of imminent lawless action. And then you got to separate the speakers from the rioters, and then oftentimes the speaker gets to keep speaking. That's the level of protection in this country we give to core political speech in a traditional public forum. That is what I wanted you to take away from tonight. Now, I have a few minutes left, so we're going to go into a little different speech that enjoys less protection or none at all, okay? There are other situations in which the Supreme Court has held that government can constitutionally restrict speech under a less demanding standard, not strict scrutiny. Again, strict scrutiny is the most intense, most powerful, most searching level of scrutiny the court ever uses. But it will allow a lesser level of scrutiny by a court of certain kinds of speech, and some of those circumstances are what I'm about to talk about. What I'm about to talk about is a little bit of a sliding scale. A lot of legal constitutional scholars don't like the court's sliding scale when it comes to speech. They don't like it. They're like, either all speech should be protected powerfully, or we don't have the right to free speech. But this sliding scale the court uses of importance gets criticized regularly by constitutional scholars. Now, I think even though if you're a purist, you don't ever want any speech restricted, I think it's important that we also imagine what the court, again, no right is absolute. No right is absolute. Even core political speech in a traditional public forum is not absolute. It almost is, but it's not. But there are other areas that enjoy less speech protection or none, or none. Here are some of those areas. Defamation, I mentioned it. Even false statements are protected speech. And but the person speaking those defamatory things or writing them can be sued. But still, while it's going on, defamation is protected speech. I mean, we know defamation can ruin people's reputations. You can be civilly punished by being sued with a civil lawsuit, or you can be criminally punished sometimes. Especially, or usually when, in fact, the speaker lied or said things they knew weren't true. The case is New York Times versus Sullivan. The problem is going to be when you're getting sued for writing or speaking something defamatory, that the speech is protected unless the speaker knows what he or she is saying is false. And then again, they can be sued. But while it's being written, the court is so worried about not chilling speech, it's going to allow the defamatory thing to be said. Of course, if I or anyone else is defamed, we can sue for a lot of money. Keep in mind what Nick Sandmann did when CNN and other major national news outlets defamed him that day because he had his MAGA hat on and that Indian was banging that drum in his face. He sat there, said nothing, and smiled. And he was called every name in the book. He was defamed. He was called, said to be intimidating, that elderly Native American man who in fact himself was the instigator. Well, CNN and some of those national publications were sued and have now paid out to that young man, Nick Sandmann, millions of dollars. So the speech got to fly. Nick Sandmann is a racist. He's down there trying to intimidate an elderly Native American. He must be a racist. He's wearing a MAGA hat. He must be a bigot. All of those ugly, nasty things that got said about Nick Sandmann were false. And he sued. But to avoid going to trial, CNN and some of the others paid him millions of dollars. So defamatory speech can have a consequence. It's protected, but if you're wrong, you can be sued. True threats. True threats. When threats are made face-to-face to people and the only purpose is to insult, that is not protected speech. While defamation enjoys lower levels of protected speech status, fighting words, what it's called true threats enjoy no protection because there is no expressive content in there. There's no value of core political speech in a true threat because a true threat, the court has said, has only one purpose, to frighten and intimidate. So defamation has less protection. True threats have no protection. Fighting words have no protection. Those are face-to-face personal insults that are very likely to lead to violence. Fighting words are not considered to have any core political value as speech. So that enjoy what are called fighting words has no protection. Now, keep in mind, the civil rights, the pro-life issue, those speakers cannot be silenced. Those words make other people very angry when you say I'm pro-choice or I'm pro-life. When you say I'm for this civil right or that civil right. People get very angry about over those things. You can't stop that. Those are not fighting words. That's protected speech. What are fighting words? Or when you go right to someone's face and say, you're a blankety blank and your mother's a blankety blank and you're a blankety blank. All insults, all profanity, it has no, in the court's eyes, redeeming value as core political speech. So it enjoys no protection. Defamation has very little protection, but it has it. True threats has none. Fighting words has none. Obscenity has none. You might ask, well, if obscenity has no free speech protected status as core political speech, why do we have so much pornography? And I'm going to tell you, and it's kind of nauseating to think about, because pornography is pretty graphic. The reason pornography enjoys protected speech status is because what obscenity is defined as is patently offensive, hardcore, sexually explicit material. That enjoys no constitutional protection as speech. Again, obscenity. It enjoys no protection if it is patently offensive and hardcore, sexually explicit material. Well, apparently not much rises to that level. And so everything else that's considered pornography in this country is protected speech, which is why we still have pornography everywhere in America. So, but again, Justice Potter Stewart tried to give a definition, and people still kind of chuckle about it. But it's hard. It's hard to know how to draw a legal standard, because where do you start and where do you stop? And I'm being the devil's advocate of a pure First Amendment core political speech purpose. What offends some people doesn't offend a lot of other people. So where do we draw the line? Who gets to decide what is offensive and what is acceptable? I mean, nude art, a lot of people say, it's too graphic, nude art. Well, a lot of art is nude. A lot of it's beautiful. The human body can be portrayed in a very beautiful way. Can that be distinguished from just regular pornography? A lot of people say, yes, it could. Other people say, no, I want to see it. So where do you draw the line? Justice Potter Stewart made the joke, that I can't really define pornography or obscenity. He said, I can't really define obscenity, but I know it when I see it. Well, how is a lower court to apply that standard? I can't really define obscenity, but I know it when I see it. That's what Justice Potter Stewart said, which people have never forgotten. That's no legal standard. You know it when you see it. Well, we don't all have your eyes and life experience, Justice Stewart. So how do we know what's obscenity? Anyway, but I want you to know about obscenity. It gets no protection, except most pornography is not considered obscenity, which is why it's all covering our society. I have 3 minutes left. Child pornography, I'm happy to tell you, enjoys no protection at all. Every aspect of it is illegal, because photographs or video involving actual children engaging in sexual conduct are punishable, because allowing that conduct, child pornography, is punishable because allowing such materials would create an incentive to sexually abuse children in order to produce that material. So to many of us, thank God, child pornography is absolutely not protected speech. People get arrested for it all the time. You cannot do it, period. Highly illegal, highly unconstitutional, the speech part. And commercial advertising. We're going to talk more about this next week, but commercial advertising includes what the state can regulate from a standpoint of health, safety, and welfare. The state's police powers, which includes Louisiana's police powers, the city of Shreveport's police powers, all those powers left to a state. The state police powers include the right to protect health, safety, and welfare of its people. Well, in governing and passing statutes, regulations, the government can limit gambling, alcohol, and tobacco. Those forms of commercial speech, in other words, solicitations, pitches to buy a certain kind of whiskey, buy cigarettes, go gambling, those forms of speeches speak to the health, safety, and welfare of people, and those areas of commercial speech can be regulated with a much less demanding form of legal analysis, way less than strict scrutiny. More like a rational basis test is what the state's trying to do by regulating alcohol, gambling, or tobacco, rationally related to protecting the people. And if it is, we're going to allow it. So I'm going to pick back up with the sliding scale, run right back through it quickly. The area is not protected, and then we're going to go on to the rest of the First Amendment. The Establishment Clause, free exercise of religion, the right to peaceably petition our government for a redress of grievances. But that was freedom of speech, core political speech, which is hugely important in our country. It's given great protection, and I wanted you to understand the standard. Strict scrutiny if there's a statute or regulation, and the clear and present danger of imminent lawless action if it's something being held immediately, like a rally in a park. All right, it's at 7 o'clock, and I'm going to see if there are any questions, but thank you if you stayed this long. I'm going to take a couple of questions. Let's see what we got today. All right, here's one. Mr. Alexander, this is from our friend in Atlanta. I forgot to tell you, we have people watching from all over. Our friend in Atlanta is asking Mr. Alexander, I don't fully understand obscenity. How is it not what we see as everyday pornography? Because it is a concept that's simply difficult to analyze. What is obscenity? What might be obscenity in Shreveport or Monroe, Louisiana, which are considered very conservative areas, might not at all be offensive or violate local community standards, for example, in Los Angeles, or God knows in Hollywood. I don't know that anything gets offended in Hollywood. It's just hard to pass a rule that covers the whole United States. And the court has struggled with it. That's what Justice Potter Stewart said. You know, I don't really know how to define obscenity, but I know it when I see it. Again, that's no legal standard to use. How do you apply that as a legal standard? You can't. So it's just got to be, again, patently offensive, hardcore, graphic, and explicit. For example, snuff films. And it's disgusting. It's revolting. But there are such things as something called snuff films, where in the video, someone kills another human being on film, a snuff film. The court has deemed that to have absolutely no constitutional protection. It's highly illegal. Obviously, it's murder. But as a standpoint of communication with expressive value, it has none. Snuff films. That's similar to obscenity, but not exactly the same. Because obscenity, again, deals with hardcore, graphic, sexually explicit material. So again, this is all debatable, but those 9 people on the Supreme Court are the ones who make the decision. Let me see if I have another question. 1 second. Okay, here's one. Mr. Alexander, how can violent demonstrations in even a public place like a park ever be stopped? Thank you for that question. That's a local Shreveporter. Those kind of demonstrations can be stopped. Again, being in a park, as I mentioned, is what's considered a traditional public forum. Back to the early 1900s, the 1800s, people would gather on the street. They gather in parks. Those are areas that are traditional public forums. And in a traditional public forum, when an issue that speaks to core political speech is what is at stake, what's being discussed. Again, race relations in the United States. That's a matter of core political speech. And if there's a speaker, say from the Black Panthers, they'd probably have to get a permit. Very likely Shreveport would require a permit for any speaker. The Black Panthers could stand in the Bay of Virginia Park and talk all day long about how white people are racist, they don't care about black people, and they should be killed. That's very offensive and inflammatory. But because it's a matter of core political speech in a traditional public forum, now there may be a lot of police out there maintaining order, but the speaker gets to be heard. Just like the Westboro Baptist, again, the small family of just crazy people. I mean, it's called Westboro Baptist, but that's not a religion that I know of. They stand outside of the funerals of slain, killed soldiers, American soldiers, and they picket, as I said, saying that God is punishing that soldier who we all believe gave his life in defense of our country. God took the life of that soldier to punish America for homosexuality. As offensive as that is, as offensive as it is happening outside the very funeral of a soldier, all of that is highly emotional, highly offensive. Those speakers, the Westboro Baptist people, get to stand. Usually they have an area cordoned off where they can yell and try to disturb the funeral. I'll tell you what, the Patriot Guard comes, though, those motorcycle riders who escort the funeral processions of these soldiers who were killed. The Patriot Guard, those guys, when the Westboro Baptist people, I've seen this happen, start screaming about how God has killed the soldier because of homosexuality, they start gunning their motorcycles to drown out that ugly or offensive speech. So that's a form of speech itself. The Patriot Guard, those motorcycle guys who form a procession and lead or follow or go alongside the coffin, the funeral, as it goes to the cemetery. When those people, when the Westboro Baptist people start screaming that offensive stuff, they start gunning their motorcycles to drown out that speech. So in a way, they're enacting their form of speech to drown out that speech. So it's a very important area. A lot of times there's a lot of emotion involved, but it's important that unless it has no value and it seriously is about to lead, there's a clear and present danger of imminent lawless action, imminent violence. It can't be stopped. Because if we're going to have free speech, if we're going to have free speech, especially when it's core political speech, it's got to be applied to everyone, even the most offensive speakers. So that was the last question. And I hope that you stayed and joined us, and we will wrap it up there, and I will see you in 2 weeks. Thank you.